Yeah, please, your lordship. Your lordship, I beg to mention for listing, your lordship. Listing of a matter, your lordship.
What matter?
Diverse matter, your lordship, for withdrawal of the case.
Make a mention memo.
Yes, yes, sir. Highly obliged, your lord.
For listing, so there was matter, appeal, I guess. So you can become
What, for what purpose?
against the, no, for praying for divorce.
Right?
Yes, sir.
What column?
Denied my divorce.
What column?
In order, sir. In order, sir. Service has not been completed. You have taken a step.
Yes, I do not appear.
Mass of it.
Well, lordship. Lordship, I beg to mention for listing, my lord, criminal appeal filed on 21/5, my lord. 21 May 5,
Okay, make an application before the registry.
When we listed
Make an application before the registry.
already.
May I please, your lordships, with the consent of the other side, I beg to mention item number 5. My senior has some difficulties today. Kindly adjourn the matter for today.
5.
Yes,
Then 22. Okay, Miss
S. Boro, on behalf of RB Boro.
as Boro, United Council. Being on behalf of Miss R.D. Majumdar, United Amicus Query. What happened? As made a prayer for HM, Miss Vivian, United Edition, as Senior Council Edition, Public State. As number of response state is pending. The appraisal of lease the case on next Tuesday.
May I please, your lordship, I beg to mention for listing of one IA, lordship, in connection with criminal appeal number 200, 2024.
IA for what?
IA for suspension of sentence.
Make an application to the district.
Lordship,
Make an application before the registry.
lordship, keep your word.
So I pray for listening a criminal appeal. If the appellant is convicted under section 302, I is dismissed.
IA?
I is dismissed, my lordship.
Huh.
So kindly list the criminal appeal for hearing.
Oh, hearing, there is already a prepared hearing list, you know? We cannot include it, go to the registry and make an application so that it can be included in the hearing list. Yes.
In this case, lordship,
Three criminal appeals.
3 criminal appeals. Out of name Jasmine lordship, common judge. In criminal appeal, 288 Mojibur Rahman.
Where is the judgment in the paper book?
87, page 87. 79, নতুন দিন। It start from 79.
87.
79. ভুল হয়েছে নাকি এটা?
79 is 313.
87 lordship এ ভুল হয়েছে। আপনি পুরোনো পেপার বুক কি লইছে আপনি? মানে 70? 87
70,000. Oh. Paper book 2.
There are two paper book.
two paper book.
One এখন আছে, তাতে 87 আর ইয়ারে 79 নেকি? Madam, I have just, okay, I have just flipped through, just paper book two, paper book two.
Paper book two is prepared by
Ah.
registry. In paper book, there was some mistakes. That is why he raised the point during the, my lordship.
Which one is the proper paper book then? Till
Second one,
second one,
lordship.
second one. Then come to page 53, both of you. Paper book two comes the proper book general.
Yes, lordship.
Flip through page 53 onwards. I just noticed. Page 53 onwards.
Lordship.
Where are the answers?
Yes, she wanted, it did, that was the mistake committed by the earlier, Honorable Judge Lordship. Thereafter, again, at the
What
time,
mistake committed by judge?
Lordship, because only the questions were there. Then at the time of hearing, it was found, Lordship, subsequently, again, the 313 was recorded, Lordship.
Where is that?
That is
Okay.
in our paper book. It is
Let us
there.
Mujibur Rahman.
Yes, yes, Lordship.
This is without any answer. Then next one is Abdul Kalam.
Yes.
It is also no answer. Ram Milan, no answer.
Lordship,
Sohrab Khan, just let me see also. Okay, no answer. Where are the answers now?
in the new paper book, it is there, Lordship.
Which one is new then?
Lordship, kindly.
You say this one
It
is
is prepared
correct,
by
this one
me.
is.
It is prepared by me. That is why Lordship subsequently.
Tell me, which one is correct?
Yes,
Please
I
tell.
will correct. I'll- New.
And what will it move? Indie please, yes. Wait to blank. 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 Yes, a second.
304. My lord, here it is written new. That was
Okay, new. Then come to page
Page
48.
48.
Come to new, if the correct one.
Lordship.
Question number one.
Yes, these are blank. Then thereafter Lordship will find at.
One by one, we'll flip through.
Lots.
Will not hurry,
Lordship.
please.
Lordship.
Don't hurry before this.
Page 48, Lordship.
Let us flip one by one.
Lordship.
We do not want to later on scratch our head.
Yes.
Page 41. Who is he? Mujibur Rahman.
Mujibur Rahman 48.
Blank.
Yeah.
Up to 52. Only last one.
Yes.
Only last one is question number 19 and 20 is filled up. Okay,
Then Lordship will find Mujibur Rahman again in 54. Which answer?
1 minute. Okay, this is again,
Again recorded.
when?
This is 22nd of
13/7.
April 19. And earlier-
Why? How it has happened?
Because Lordship, we have no idea regarding this, regarding 313. They have given their statement before the court. But after that, it was not recorded because We have no
So
idea.
how it was subsequently came to be recorded?
Yes, Lordship, during the hearing, during the argument time, Lordship,
During the hearing of which one?
during the argument of this case.
Before the trial court or before the
Be-
appeal?
Before the trial court.
Ah.
Before the trial court, again, the learned judge has found that this was not recorded.
Where is the
Again,
order? Show us.
earlier one is 30.
Show us from the case.
Lordship will find at page number, it is order sheet 2. 22nd of April 2019.
This is recorded, but how it is recorded? People wrong. Second of April, 2019. Jibu. Media my question. For them who wrong good money.
Lordship is recorded in.
Kasih pada polis. Itu di sini jauh. Betul. Surat. Surat PPS ini. Surat PPS lah. Oke. Yeah, what's,
9/4/2019. Two times. Lordship. Statement 2 times.
Hmm?
Statement recorded 2 times. Lordship.
I have seen.
In this case, Lordship,
What is the, offense?
offense is, Lordship, recovery of morphine and opium, Lordship. From 4 persons.
Why is the sentence?
Sentence is about 20 years, Lordship.
The sentence, all four.
All 4.
No, section. Hey, indicate.
148.
148.
148.
Why under section 17C and 21C? Separate sentence?
Lordship, 71C for opium.
17C,
Sorry, 17C for opium.
commercial.
C is commercial, 17
17C, opium commercial quantity.
commercial quantity.
And why then 21C?
21C wrong, this is Act Lordship, this is
17C is specifically for opium.
opium,
That I have understood.
Lordship. 21C. Actually, this is, there is another contraband that is, I think for that, morphine is there,
Morphine.
morphine.
It is, entry is opium. Let us see the table
Schedule.
schedule. Opium,
Opium at Lordship will find at serial number 92.
92.
Yes. Morphine.
Opium. More than 25 kg.
More than 2.5 kg.
20, more than 25 kg, if it is to be commercial. And where is morphine? Morphine,
77.
5
Morphine
kg,
77.
5 kg. 5 kg is commercial.
Oh.
Yes?
Lordship, may I point out one thing, Lordship?
Ah,
2.50 gram.
that is intermediate, small quantity.
2.50 gram is commercial quantity for morphine also.
Then why that next column was there? Madam,
Small quantity is, Lordship, 5,
okay,
5 gram,
5 gram, 250 gram.
250 gram,
Okay, and for
Opium.
opium, it is 2.5.
2.2.
Okay, good. Morphine was also there.
Yeah, morphine is also there. Take on
250.
21 for
Okay, 2020.
20.
And what is that? Conjugative or concurrent?
Concurrent. And
All four.
all for all food.
Hmm. Yes. Where from to start?
Lordship, in this case, on
Tell
On-
me first your bullet points.
bullet points, Lordship, in this case, on last 12.
Yes, Mister.
Okay.
Ready?
Mhm.
I have assisted.
Ready?
Ready.
No, you ready or not?
Ready.
I have assisted. So my.
Huh?
You are,
Then check yourself out medically.
Lordship.
The others went had fallen because the Advocate General Nagaland contacted COVID.
I have examined for typing my.
Lordship, in this case, what happened, Lordship, on,
You tell me first your salient point, then we will hear.
I would like, before that, Lordship, I'd like to point out one more thing, Lordship. On 10, 12,
You represent all the appellants?
yes, along with my senior HR students. He will come. Lordship,
So if the facts are similar, we'll not hear to counsel. If
specs
the
of senior-
facts are similar,
out of,
we'll not hear to counsel.
Lordship,
So if I hear you, I'll not hear. Sure.
Lordship may hear me, Lordship.
All.
So in this case, Lordship, what happened on 10, 12, this honorable court has, we have raised a point that they have served about 10 years punishment. From the date of arrest, they were inside the jail. So we are on that, Lordship. Lordship may reduce the punishment till Lordship take to 10 years. So, that honorable bench has reflected in the order sheet, Lordship, on 10, 12, 2024.
10,
10, 12, 2024.
ten, 12.
10, 12.
How a hearing on sentence can be made
Lordship, here in
without going into the merit?
merit, Lordship.
Is there any authority?
So
Yes.
we have collected some authorities, Lordship, from Apex Court as well as from the other High Court.
Apex court may have 142 power.
Lordship, before that, Lordship, kindly go through the section 32B of the NDPS Act.
And what is the outcome of the Supreme Court?
Supreme Court, Lordship, in one letter judgment, Rafiq Hussain. In that case, 18 years conviction was imposed, Lordship, and then the
No,
other
you mentioned about that when
paragraph.
that some judgment was reserved on.
Oh, that
12
has been, Lordship, that has been declared. That was in regards to the bail. And Lordship, that is there,
bail.
bail. But Lordship, thereafter in appeal, we found one judgment, Lordship, that is decided, but some factors are there. If Lordship want to hear on that point, I will like to place that judgment also. Regarding 50, here in 52A is not, has not been complied with, Lordship. But in Bharat Ambale case, Lordship, decided by the Apex Court, it is stated that, Lordship, non-compliance of section 52 is not alone the ground. Some factors must have to considered by the court.
Okay, we'll
That-
look
that
to
is-
the case then. Let us see the appeal then we'll decide.
Lordship, in this case, in Bharat Ambale, it is cleared, Lordship, that if in other cases, like Lordship pass judgment in one case, there are some factors that they have not complied with, like independent witness or in the contraventions in possession like this, Lordship. In the Mungilal and other, whatever passed by the Apex Court, in that case also cited. In that case, why that was not overruled, Lordship. In that case, Lordship, other factors also considered along with section 52 that has been directed in this Bharat Ambale case,
Okay,
Lordship.
let us see your case then.
My case is, Lordship, on the basis of the information, Lordship, on 6
Where is the information?
information at
Exhibit
page 1.
Page 1.
Before that, Lordship, in this case, as many as 6 witnesses by the prosecution and 2 DW.
Okay, we'll look into that.
Lordship.
We'll go serially
Yes,
to understand.
Lordship. Page 1 is information, Lordship, NCB 1, Exhibit 3.
This is in compliance of section
It is on the basis of
41.
42,
42.
Lordship. On 6/5/2016, an information was received by PW3 that was
Yes, read,
Lords. May I read the gist of
Mm.
information, Lords?
phase one.
Yes. Today that is on 6/5/2016, my casual informer informed me that two persons, namely Muhammad Abdul Kalam and Mujibur Rahman, will be going to deliver a consignment of morphine and opium to the two other persons, namely Saurabh Khan and Ram Milan, near the entrance of Indira Gandhi Stadium, Korukozai, Guwahati at 7 a.m. on 7/5/2016. He requested to intercept them. This was reduced into writing and forwarded to the superior officer. This was exhibited before the trial court also.
So strange. You know. Seven AM, seven.
Yes. They received the
It was in the evening of 6/5.
yes. 6.
Okay.
Then it was reduced into writing, Lordship, placed before the superior officer. Then on 7 a.m., they are supposed to intercept the persons. So after that, Lordship, they went to the place of occurrence and then they called two person from that area and they made the witness in this case at the time of search and seizure. PW1 is the FSL expert, Lordship. That is, I think, no needed to read, Lordship. And this
1 minute.
one is FSL expert, Lordship.
Come to page 2.
Lordship. Yes,
Uh,
it is.
this is, charges were framed under section 21
Yes,
C and section 29.
that is corrected in the judgment. Without will come
Huh?
later on. Yes, Lordship. Without getting the
Please
opportunity.
clarify.
Yes,
just While going through
Lordship. It is reflected in the
21
judgment.
C and 29,
29.
how it is corrected?
It is without getting the opportunity
Let
to
us see which
in the
one.
judgment part, Lordship.
Uh,
Also need to page number. Lordship will find at page number 114. It starts from 114. Paragraph number 81. May I read, Lordship?
Page 1. No, 1 minute. Paragraph
81.
paragraph.
Paragraph 81, Lordship.
I
81.
am taking the paper book 1.
New.
New.
144.
144. See it again.
Page 144. In the judgment.
114. Page
In
114.
our page, Lordship, the bottom, Lordship,
Tell me the paragraph then.
81. Lordship, got it. Eighty-four change queries.
81, paragraph 82, 83. It is.
This is 88, he has decided, Lordship, after discussions, Lordship.
Yes, how, so till the judgment, charge under section 17, 21C, 21C or 7?
21, 21.
No, it was framed. 17C was not framed. Then.
Charge not frame under 17C.
Right. So, what is your submission on it?
In this Lordship, this has been wrongly, without getting the opportunity, search,
It is a law.
there's a law. But
It is a law. He said 215.
Charge can be altered, but one opportunity.
So
should
it is
be-
up to you.
Lordship, no, Lordship,
Just because the source can be altered, it is up to you. I'll
Lordship,
record only that.
no, Lordship.
Take your call.
215.
Is it your ground of appeal? No.
Any other grounds are there, Lordship? We have pointed out this thing. Specific, those specific point is not any other ground.
Specific no ground.
Specific no ground. Lordship. This is second, additional this one. No, it will be. So,
Okay, take your call. Go on, argue.
in additional grounds, we have taken Lordship. Some additional grounds we have taken. In that, we have taken this plea also in para number 9. In additional grounds, Lordship. We have filed this.
Okay, take your call.
So, 200, 15, 15.
Who is the material witness here?
Here, Patel is only PW3 because the others are team member and there is
Okay,
no
let us see PW3 first.
PW3. PW3 will find Lordship at at page number 10.
Hmm.
May I read, Lordship?
Hmm.
On 6/5/2016, I was working as intelligence officer in Narcotic Control Bureau, Guam. On that day, at about 5:30 p.m., I received an information from my informer that 2 persons, namely so and so and so, would be going to deliver a consignment of morphine and opium to other persons, namely Saurabh Khan and Ram Milan near Indira Gandhi Stadium, Purukosai, Guwahati. On that very day, immediately after receiving the information, I reduced the same into writing. It was informed to my superior, namely Sanjan Sir, Guwahati Zonal Unit. After that, office order was issued by Zonal Director, namely Praveen Kumar, deploying 10 persons worked up operation. I myself was seizing officer as per the said office order dated Chandraji. Exhibit Chandraji, NCB 1 reduced into writing. Exhibit 4 is the said office order issued by Zonal Director. On the next day, that is 7/5/2016, as per office order, we left NCB office at 6 a.m. After reaching near Indira Gandhi Stadium, Purukosai, Guwahati, we approached two persons who were walking on the road and told them about the information available with us. We also give our introduction of the members of the team and requested both of them to be independent witness of the process of search and seizure, if any. When we reached the spot, along with independent witness, one white color Scorpio vehicle bearing registration number was seen parked on the service road. At about 6:30 a.m., one truck bearing registration number reached near the Scorpio. After that, two persons from the Scorpio came out and went near the truck. Two persons who were sitting near the truck also came out, and these four persons discussed something for about 1 minute. At that time, the team was indicated by the informer that these were the four persons who were trafficking the opium and morphine. After that, one person entered the cabin of the truck and handed over few polythene packets to the persons who were standing near the truck. We rushed towards the said truck and Scorpio. When we reached near the said vehicles, all the four persons were standing near the said truck with polythene packets in their hands. Thereafter, we introduced ourselves to them and we told them about the information available with the team. On asking the four persons, they identified themselves as Abdul Kalam, Mojibur Rahman, Muhammad Saurabh Khan, and Ram Milan. These four persons were present near the truck. During body search of the four persons and their belongings, provisions of sections 100 CRPC were followed. Before conducting body search, we served notice under section 50 of NDPS Act to all the four persons. They acknowledged the same and gave the written consent of the body search. Exhibit transactions are the acknowledgement of copy of the body search issued to them under section 50 of NDPS Act. Thereafter, the said four persons gave written consent in presence of the independent witnesses. The written consent of the four persons specifically stated that they did not need the presence of any magistrate or any other gazetted officers at the time of body search. Exhibit transactions. These are the consent letter and in their handwriting. On opening the plastic bags carried in both hands by the accused, Saurabh Khan, dark brown color sticky material was found packed in two packets wrapped by brown color cello tape and kept in white polythene packets. A small quantity of dark brown color sticky material was taken out from both the packets and tested with the help of drug detection kit brought by the NCB team, and both materials gave positive for opium. Both white plastic bags were marked as C1, C2, and packets containing dark brown color sticky material were marked as P1 and P2. On weighing with the help of digital weighing machine in presence of two independent witnesses and four suspected persons, and weight of P1 and P2 was found to be 10.12 kg gross and 10.148 kg respectively. The opium was seized in presence of the two independent witnesses and four accused persons drew one sample in duplicate of 24 grams each and marked as S1 and D1 and S2 and D2 respectively. All the four samples were duly packed in polythene and then kept inside an envelope All the samples and seized dark brown color sticky material suspected to be opium was sealed with NCB Brazil number 1 and properly labeled, and signature of the independent witnesses and 4 accused persons and seizing officer were also taken on them. The polythene bags carried by Muhammad Mujibur Rahman was searched, and opening the said bag carried by him. Dark brown color sticky material was found in one packet wrapped by brown color cellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from the packet and tested with the help of drug detection kit, and the material gave positive color of opium. This white plastic bag was marked as C3 and packed containing dark brown color sticky material was marked as P3. On weighing, the sticky was found to be 10.11 kg, was the opium was seized. The then drew one sample in duplicate of 24 gram each in presence of independent witness and 4 accused person and marked as S3 and D3. The samples were duly packed in polythene and then kept inside on the envelope. All the samples and seized dark brown color sticky material suspected to be opium was sealed with brush seal number 1 and properly labeled, and signatures of the independent witnesses, 4 accused persons, and the seizing officer was also taken. The polythene bags carried by Ram Milan were searched, and on opening the plastic bags carried in both hands by Ram Milan, the dark brown color sticky materials was found packet in 2 packets wrapped by brown color sellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from both the packets and tested with the help of drug detection kit, and both materials gave positive for opium. Both white plastic bags were marked as C4 and C5, and packet containing dark brown color sticky material were marked as P4 and P5, and weight of P4 and P5 were found to be 10.168 kg and 10.208 kg respectively. Then the opium was seized. Then, in presence of 2 independent witnesses and 4 accused persons, drew one sample in duplicate of 24 grams each and marked as S4 and S5 and D5 respectively. All the 4 samples were duly packed in polythene and kept inside on the envelope. All the samples and seized dark brown color sticky material suspected opium was sealed with brush seal number 1 and properly labeled, and signature of independent witnesses. All 4 accused persons and seizing officers was also taken. The polythene bag carried by Muhammad Abdul Kalam were searched, and on opening one of the plastic bags carried by Muhammad Abdul Kalam, dark brown color sticky material was found packed in one packet wrapped by brown color sellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from the said packets and tested with the help of drug detection kit, and the material gave positive test for opium. The white plastic bag was marked as C6 and packet containing dark brown color sticky material was marked as P6, and on weighment, the P6 was found to be 3.878 kg. The suspected opium was seized, and then, in presence of the independent witnesses and 4 accused persons, drew one sample in duplicate of 24 grams each and marked as S6 and D6. The samples were duly packed in polythene and then kept inside as envelope. Both the samples and seized dark brown color sticky material suspected to be opium was sealed with brush seal number 1 and properly labeled, and signatures of the independent witnesses and 4 accused persons and the seizing officers was also taken. On opening the second plastic bag carried by Muhammad Abdul Kalam, brown color powder was found packed in one packet wrapped by brown color sellotape and kept in white polythene. A small quantity of brown color powder was taken out from the said packet and tested with the help of drug detection kit, and the material gave positive for morphine. The plastic packet bag was marked as C1 and packet containing dark brown color powder was marked as P7, and on weighing, the P7 was found to be 2.060 kg. The suspected morphine was seized, Then, in presence of independent witnesses and four accused persons, drew one sample in duplicate from 5 grams each and marked as S7 and D7. Both samples were duly packed in polythene and then kept inside as envelopes. Both the samples and seized dark brown color powder suspected to be morphine was sealed with brush seal number 1 and properly labeled, and signature of independent witnesses and 4 accused persons and seizing officer were also taken. During the personal search of Muhammad Abdul Kalam, one PAN card in the name of Muhammad Abdul Kalam and Indian currency rupees 5,000 were recovered. During personal search of Muhammad Saurabh Khan, one PAN card in the name of Saurabh Khan and cash of Indian currency of rupees 7,000 were recovered. Personal search of Ram Milan, one PAN card in the name of Ram Milan and cash of Indian currency of rupees 3,000 were recovered. And during the personal search of Mujibur Rahman, one copies of document related to the ownership of the truck and cash of Indian currency of rupees 2,000 were recovered. All the recovered documents during the personal search of all 4 persons were kept inside as envelope, and money was kept in another envelope duly marked and sealed by NCB brush seal number 1 and properly labeled, and signatures of independent witnesses and 4 accused persons, and the seizing officer was also taken. Both the vehicles, that is truck and Scorpio, were searched, and on searching the Scorpio, we found that special cavity has been made and the vehicle number so and so and so. On inquiry, accused Saurabh Khan admitted that the vehicle number so and so is registered in his name. He also told that he had made a special cavity for trafficking of drugs. Then the said Scorpio was seized, and on inquiry, it was told by one Mujibur Rahman that truck bearing number so and so was registered in his name. He also told that he had brought the said consignment of opium and morphine from Imphal in the said truck, and the said truck was seized and copy of insurance premium slip of the truck number so and so issued by United India Insurance Company Limited and public carriers permit issued by Transport Authority Thoubal against the vehicle numbers and so were also seized. On inquiry, all 4 accused persons admitted their involvement in trafficking of drugs. They also revealed that they were doing illegal trafficking of morphine and opium for the last many years for monetary benefit. Thereafter, on reasonable belief that as offense has been committed under section so and so and punishable under 21C, 17C and 29 of NDPS Act, the entire consignment believed to be opium and morphine was seized under section 43 of the NDPS Act. The search cum seizure list and the Panchnamas were prepared on the spot. The seizure process were completed at about 12 p.m. on 7/5/2016 in presence of independent witness and 4 accused persons. Exhibit 18 is the search cum seizure list. The is my signature. The search cum seizure list was prepared in presence of independent witnesses and 4 accused persons. Then Lordship, Exhibit 19 is Panchnama dated 7/5/2016, which was prepared by me in presence of witnesses and the 4 accused persons. After that notice under section 67 of NDPS Act was issued to the 4 accused persons on 7/5/2016. Exhibit 20, 21, 22, and 23 are the copy of notice under section 67 of NDPS Act issued to the 4 accused persons, namely Saranjans. The notice under 67 of NDPS Act issued to them for regarding the voluntary statement of the 4 accused persons. The voluntary statement of accused Ram Milan was recorded on 7/5/2016. As per statement, he stated that he has been involved trafficking to illicit drug for the last 3 years for monetary benefit. Exhibit 24 is the voluntary statement of accused Ram Milan in Hindi language. Then his signature. The voluntary statement of accused Mujibur Rahman was recorded on 7/5/2016. As per statement, he stated that he has been involved trafficking to illicit drug for last 3 years for monetary benefit. Exhibit 25 is the voluntary statement of accused Mujibur Rahman in English language. The voluntary statement of accused Abdul Kalam was recorded on 7/5/2016. As per statement, he stated that he has been involved in trafficking to illicit drug for the last many years for monetary benefit. Exhibit 26 is the voluntary statement of accused Abdul Kalam in English language. The voluntary statement of accused Saurabh Khan recorded on 7/5/2016. As per statement, he stated that he has been involved trafficking to illicit drug for the last 3 years for monetary benefit. Exhibit 27 is the voluntary statement of accused Saurabh Khan in Hindi language. After record,
Just a minute, out of these four applicants, who were in the Scorpio?
Scorpio, Saurabh Khan and Ram Milan.
Huh?
Saurabh Khan and Ram Milan in Scorpio, Mozibur.
Scorpio,
Yes,
Ramilon,
yes.
Milon, and Abdul Kalam,
Abdul
Prak,
Kalam and Mozibur Rahman were in Prague.
Prak. Okay. So, this,
These are the three
Uh,
cross-part lordship. Some more thing is at page number 20 lordship
this
regarding
Prak
re-
occupants
occupants.
engage their defense counsel separately from the Scorpio occupants.
Yes. So, lordship, some regarding non-compliance of section 52, they have stated in page number 20.
Yes.
Page number 20 from the top lordship. I have received a sample S1 to S7 for sending them to FSL Kahilipara. I have received the samples. Then these exhibits, test memo and receipt of the FSL. Then exhibit 9 is the compliance report under section 67. Compliance report should be written as 57, but here it is mentioned as 67 of NDPS Act in connection with NCB crime number 4. So thereafter, exhibit 33 is the inventory under section 52A of the NDPS Act, where exhibit 32, 33 and 33(4) are my signatures. It is very important, lordship. It's a exhibit 32 in the same number, 2 exhibits were there. 33. What's the exhibit 33?
Page,
Madam, page 33.
page
Lordship, page 219.
219, we don't have.
And then
Where where you have read?
I have,
Page,
this is
page?
page 20.
20, which part?
Lordship will find that the exhibit 9 is found, lordship got it. Then next, exhibit 33. Exhibit 33 is the inventory under section 52A of NDPS Act, where in the thereafter, before exhibit 9, lordship will get this exhibit 33 is the receipt of office
Okay.
of the FSL.
But my first question will be,
Lordship,
there may be mistake.
my lord.
If there are two exhibits,
We are not,
both number 33,
yes, yes.
that could be a mistake.
We are not,
If both are in existence,
that is there,
both
lordship.
are in existence or not? Exhibit 33, that is the receipt of office of the FSL,
It
that
there.
is in existence.
Yes.
And next one, 33, inventory, that is in existence.
Yes.
Then doesn't matter. There is not a material.
We are not on that. Do
Then
not- we have some other.
that may
defense
be a different thing.
Lordship,
But this,
Lordship,
mistake- this-
we are not on that mistake. We have corrected that thing from both sides, Lordship. But
so exhibit 33, there are two.
in numbering, there may be mistakes, Lordship.
Ah.
But it is exhibit 33, which related to inventory. Lordship, look into that at page 220. Then two
That
hundred,
is exhibit 33, first one.
first one.
Next one, 221,
Yes,
221.
221 is inventory. Lord.
Huh.
That is, it is written this way. With columns.
Original from like exhibit 33. We do well. Yes, we have seen. Now what is it?
Inventory in origin. It is, not as per the section 52A. Inventory not as per section 52A notes. Section 52A, subsection 2.
Point out from this page 22 to 22, 24, what is
Yes.
wrong in it.
Only what I have. I see. Lordship. Take a look.
এটাতে আছে। Yes, record. Yes, record. Oh. all the 5 bags were materially exhibited. P1, P2, P3, of 7 bags. All were materially exhibited. Through PW3.
Three.
Okay. Now you have to,
But all the contrabands is there packing sample collected on the spot and all the packets.
okay, but here is a case where all the bags, P1 to P7, were produced before,
Before
that,
the trial board. Lordship.
right?
Yes. Then Lordship. And though produced before the court regarding subsection 4 or subsection 2, Lordship, certification is not there. And then samples thereafter not collected before the magistrate, and subsequently, Lordship, in this case, no application made under section 3, and notwithstanding in 4, the photograph also not taken, Lordship, as a primary evidence.
The question is here. Inventory is not under subsection 4 of section 52A. It could be a situation because if the original contraband in packets were not produced as the primary evidence, right? Subsection 4 of section 52A says, notwithstanding anything contained in Indian Evidence Act or the CRPC, every court trying an offense under this act shall treat the inventory, photographs of narcotic drugs, psychotropic substances, controlled substances, or conveyances, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence, right? The difference is that when the original is not produced,
But
subsection 4, please understand,
yes, yes.
right? This is inventory is a substitute of the primary evidence.
But regarding list of sample, Lordship,
See also,
shall treat
the other case where you made submission, the original was also not produced.
but the
The
samples.
bag were not produced,
bag
if
is
I remember correctly.
Yes, yes, bag was there.
Bag were not, so primary
No,
evidence,
In that case, Lordship,
One
bag
minute.
produced. Bag produced.
primary evidence as per Evidence Act. The thing is to be produced. This is an alternative. Subsection 4 is alternative. That is an alternative special provision is made. So far, if I remember correctly, on proof, Evidence Act.
Section 62 of all when.
61. The thing is to be produced. The primary evidence means the document itself produced for the inspection of the court. So basically, if the bag itself is produced, its photograph is not required to be produced.
It might a list of samples.
We'll look into that,
Yes.
but here is a case. Inventory is not required to be produced if the main thing is produced. It could be a situation. It is not unlike the other one where the main bag was not there. And 52A compliance is also not there. But here is a case I have found that P1, P2, P3, P4, P5, P6 and P7 were produced before that. There is no whisper about any denial. I have gone through the cross-examination. There was no denial about P1 to P7. Is there any denial? Please take it to me because we will see one by one so that things are registered
Yes.
in our mind. Is there anything? Oh. Let us read the entire thing.
Lordship,
It will be better
Lordship.
because you made it open, I think. You made it open. The backs, you made it open, looks like. Let us hear it.
Yes, yes,
At your instance, the bag was open before the court.
yes. Material exhibit 1.
Start from page 29.
Cross. Saurabh Khan and Ramini.
You completed the other part, perhaps?
Lordship, other part is there regarding.
Anything material there? Because I have seen math
that-
EXT, all these are math EXT,
Yes,
right from page 12.
right from, Lordship,
Page 12.
Uh.
Oh, sorry, 21. 21.
21.
All these are math EXT I have
Yes,
seen, right?
yes. All-
There is, I think, no denial. It contains magistrate's signature. Let us see what you have
this is
disputed.
the chief part, materially exhibited.
All up to
to
material
20.
exhibit 18.
Yes. 18,
Now,
page 24.
what you have contested, let us see.
Lordship,
If you want to read from page 25 also, you can read.
Lordship. Page 25, Lordship.
Ha.
In material exhibits 357, there is no signature or any seal of the godown in charge of NCB, and godown entry number is also not mentioned in material exhibit number 357. In,
Godown in charge is PW 1 or 2. We'll look into his.
Two.
We'll look into his.
in the material exhibit 8 to material exhibit 15, there is also no signature and seal of the godown in charge, nor there is mention of godown entry number. In para 3 of the offense report, there is specific mention that the accused persons were indicated by the informer. On being asked, the accused persons introduced themselves by their names. In Exhibit 3, the proper descriptions of the vehicles were not given, and in NCB 1, there is also mention of the truck number so and so and so. It is not a fact that the facts mentioned in NCB 1 do not tally with the facts stated in the para 3 of the offense report. In NCB 1, the reference number has not been mentioned. In NCB 1, the short signature of the informer is there, but I will not disclose the identity of the informer. In Exhibit 3, I did not mention the time when the information was forwarded to the superior, but I sent it immediately. Superintendent Tulika Morang did not give a separate note that she had received the information. She did not mention the time when she had received the information. The zonal director did not give a separate note that he had received the information and at what time he had received the information. It is not a fact that Exhibit 3 was prepared after completion of search and seizure. At the time of search and seizure, I requested the local people to be the witness of search and seizure. In Sri Dimbeshwar Bosumatar and Sri Nilab Raskwa agreed to be the witness of search and seizure. They were not examined, Lords.
Okay, we'll look into that.
It is not a fact that Sri Dimbeshwar Bosumatar and Sri Nilab Raskwa were not independent witnesses. Rather, they are stock witnesses. It is not a fact that at the time of search and seizure, I did not call any independent witness. Now, in the office order forming the team, I was empowered to be search and seizing officer. There was no separate authorization method. It is not a fact that I have not been authorized by this office order. There is no documentary report that at the time to leave for search and seizure, I carried with me the official papers, weighing machines, departmental seal, envelopes, and other necessary documents to the place of occurrence. In Exhibit 19, the Panchnamas, I mentioned there was special cavity in the Scorpio, but the word secret cavity was not mentioned. In Exhibit 18, there is no specific mention under which provision the search and seizure was conducted. In Exhibit 18, I did not mention the color of the seized contraband. I also did not mention in Exhibit 18 the color of specific bag in which the contraband were wrapped. In Exhibit 18, I did not mention about the seizure of the truck and the polythene bags polythene bags marked as C1, C6, and C7. It is not a fact that I did not give the note to the search and seizure memo was prepared in presence of the accused person, but there is note that they put their signature. In the search and seizure memo, I did not mention that immediately after the search and seizure, the seized contrabands were wrapped with white marking cloths and labels were pasted. I did not prepare a separate women's sheet of the seized article. I did not prepare any sketch map of the place of occurrence where the search and seizure was conducted. In Exhibit 33, I showed the color of the exhibits as a deep brown color. In Panchkama Exhibit 19, I mentioned the color of the seized dark contrabands as dark brown color. I did not mention in Exhibit 33, that is the inventory, the mode of packing, contrabands of the contrabands marking or any specific mark in the packet. I did not find any application before a magistrate for certifying the correctness of the inventory so prepared by me. In Exhibit 6, the godown received number 6 and 6, 7, and 8. There is no mention depositing the plastic bags in the godown along with the contraband packets. The memo number which is mentioned on the sample package was not mentioned in the test memo. The witness added it is not required as it is enclosure. I explained the provisions of the Section 67 of NDPS Act to the accused persons before recording their statement. I did not give it in my handwriting that before recording the statement of the accused persons under Section 67 of NDPS Act, I explained the provisions to them. In Exhibit 25 and 26, there is no mention of the case numbers in which the statement was recorded. I did not include the qualification of the accused persons before recording the statement under Section 67 of NDPS Act. The statement was written by the accused persons themselves, namely Mujibur Rahman and Abdul Kalam, in my presence, but it was written in English. Statements were voluntarily written by accused persons themselves, and I cannot say why they did not write in their mother tongue or language. It is not a fact that since the statement were not voluntary, the same was not recorded in presence of independent witnesses or in presence of the any gazetted officer. It is not a fact that our officers gave the club to the accused persons who were in custody at that time and compelled them to write according to our clubs, while the accused persons themselves wrote their statements under Section 67 NDPS Act. There was no question of read over the same again to them. It is not a fact that Exhibits 16 and 17 are not the consent given by Mujibur Rahman and Abdul Kalam. It is not a fact that I did not comply with the provisions of Section 50 of NDPS Act before body search of the accused persons. It is not a fact that I apprehended the accused persons from Abdul Kalam from Reach to Sultan Bazar at 7 p.m. It is also not a fact that I apprehended accused Mujibur Rahman from ISBT Guwahati at 6 p.m. It is not a fact that accused persons Mujibur Rahman and Abdul Kalam were not at the place of occurrence on the date and time of occurrence. It is not a fact that Exhibit 3, 5, and 7 were not seized from the position of the accused Mujibur Rahman and Abdul Kalam. It is not a fact that the said two accused persons did not carry any contraband with them and nor we seized any contraband from their position. Then cross of Saurabh Khan and Ram Menon. The information was not written in the handwriting of the informant and submitted before the superior officer in closed envelope before preparation of NCB 1. After reducing the information into writing, the thumb impressions of the informant was not taken in the said sheet and not sent to the superior officer by separate forwarding letter. In Exhibit 3, NCB 1, only the name of the accused has been mentioned. The name of their parents and addresses were not mentioned in Exhibit 3. In column number 7 of NCB 1, it was written that the suspected contraband would probably be in the cabin of the truck number so and so. In NCB 1, in the gist of information, the probable mode of delivery of suspected contrabands and how it was likely to be done, or in which vehicle it was likely to be delivered or carried, was not mentioned. In NCB 1, there is no mention of the gate number of Porkoza Stadium where the alleged delivery was probable to be done. In NCB 1, under short signature of the informer, I did not give any certificate to that effect that it was the signature of the informant. In NCB 1, no official shield has been used either by me or by the superintendent or by the general director. It is also not written in the paper having national emblem. Along with Exhibit 3, NCB 1, no extra forwarding has been given or attached. It is not a fact that regarding sending of NCB 1 to the superior officer, I did not convey the provisions of section 42 of the NDPS Act. It is not a fact that NCB 1 was not prepared prior to the interception of the accused person and prior to their search and seizure and arrest. It is not a fact that NCB 1 was prepared subsequently only to manipulate the record. In Exhibit 4, the office ordered name of the accused persons or the name of the vehicle to be intercepted were not mentioned. It was only mentioned to proceed to Indira Gandhi Stadium, that is Porkoza Stadium. Exhibit 4 office order was issued by Zonal Director, and I cannot say why it was not mentioned or whether it was necessary to mention, as the document was signed by my senior officer and I cannot explain his actions. In Exhibit 4, the case number as mentioned in Exhibit 3 was not mentioned. The copy of the movement registered is not with the record. We had no information that the vehicle bearing registration number so and so to be intercepted in front of gate of Porkoza Stadium, but on the reaching there, we found that the vehicle was parked at the service road of Porkoza Stadium. I did not specifically mention at which service road of the stadium it was parked. It is true that we had the information of the truck number, but on the previous day, we did not start any inquiry regarding the truck. We did not do it because the delivery time was at 7 a.m. on the next morning. We did not inform any other security agency remained in charge of Porkoza Stadium or any other staff working inside the Porkoza Stadium. We did not think it necessary to call their assistance. We did not take assistance of Papa duty staff or Bojisto PS at the time of interception of the accused persons. We did not call on duty security staffs at the gates of Porkoza Stadium. I did not see any coach or player inside the stadium, as because I did not enter inside it and I did not call any of them to be witness. As we got two independent witnesses to agree to be witness of search and seizure, we did not charge for any other witnesses. We did not call any CCTV footage of the cameras installed in different gates of Porkoza Stadium. The independent witnesses were not from the same locality where the interception took place. It is not a fact that both of the witnesses, Dimbeshwar, Busumat, and Nilab Raskwa, were stock witnesses. It is not a fact that no such incident as deposed had taken place in the locality for which we could not collect the evidence of any local witnesses. It is true that in the format of notice under section 50 of NDPS Act taken by me at the time of movement to the probable place of occurrence, I did not type the names of the probable accused persons. It is not a fact. It is written by me in my own handwriting at the spot. It is not a fact that prior to movement to the place of occurrence, we had no information regarding the names of the accused persons and their addresses, and that is why we did not type the names and addresses of the accused person from before. In Exhibit 14 and 15, the consent letters, it is not mentioned that substance of notice under section 50 of NDPS Act written in English was explained in Hindi, but in the said consent letters, it is not mentioned who had explained the same in Hindi. The witnesses in the consent letters put their short signatures. The names under the short signatures were written by me, but there is no mention in the said consent letters that I had written the same. It is not a fact that no notice under section 50 of NDPS Act was given to the accused persons, nor it was explained to them. It is also not the fact that we compel the accused persons to put their signatures in the blank format of the notice under section 50 of the NDPS Act. It is not a fact that I did not comply with the requirements of section 50 of NDPS Act. The polythene carry bags marked by me as C1, C2, C4, and C5 were not seized by me as per Exhibit 18. Exhibit 18, there is no mention that Scorpio vehicle was seized by me. From the accused Saurabh Khan, we had recovered 2 packets suspected contraband containing respectively. From the accused Ram Milan, 2 packets of the contrabands containing so as Exhibit 1. In Exhibit 18, the independent witnesses put their short signature. It is not a fact that at the time of preparation of Exhibit 18 and 19, there were no independent witnesses. I did not take the signatures of the members of the team accompanied with. In the inventory, Exhibit 33 prepared by me under Section 52A of NDPS Act, in column number 1, I wrote packets P1 to P6 contain dark brown powder believed to be opium. It is true in Exhibit 5, 6, and 7, that is go down receipt, the weight of P1, P2, P5, so and so and so. It is not a fact that I did not take the weight of the seized items properly, and as such there is discrepancy in seizure of articles and the quantities shown in the go down receipt. In Exhibit 7, go down receipt number 3, there is no mention about facsimile seal. In Exhibit 20 and 22, that is the notice under 67 of the NDPS Act, I asked the accused persons Saurabh Khan and Ram Milan to give their statement in front of the gate of Farrukhazai Stadium, Guwahati at 12:30 p.m. In his statement recorded under Section 67 of NDPS Act, as Exhibit 27, Saurabh Khan stated that he had appeared for giving his statement at 4 p.m. He did not specifically mention where he had appeared. In Exhibit 24, that is statement of Ram Milan, recorded under Section 67 NDPS Act, he stated that he had appeared at NCB office for giving statement under 67 of the Act. We started operation at 7 a.m. and the search and seizure procedure was completed 12 noon. Thereafter, we issued notice for recording the statement of witnesses. They were asked to appear 12:30 p.m. and it continued till evening. It is not a fact that accused Saurabh Khan and Ram Milan were picked up later on and they were compelled to put their signatures in a blank sheet, which was converted subsequently to their statements under Section 67 of NDPS Act. It is true that accused Saurabh Khan was at Hotel Fortune, Paltan Bazar from 5 2016.
16. Yes.
It is true that Saurabh Khan in his statement stated that he had checked out from the said hotel on 6/5/2016 at 9 p.m. I did not investigate or inquire at Boshishtha Sariali according to the statement of accused Saurabh Khan, where he had taken shelter from the night of 6/5/2016 till 7/5/2016 morning. I did not visit the hotel person to inquire about the presence of the accused Saurabh Khan in that hotel. I did not record any statement of the accused person in questionnaire form. I did not take measurement of the special cavity in the Scorpio nor take photographs of the said cavity. I did not approach the MBI Guwahati to measure the length, breadth, and depth of the said cavity. It is not a fact that I did not comply with the provisions of Section 52A of NDPS Act. It is not a fact that accused Saurabh Khan was picked up in front of the Hotel Fortune situated at Paltan Bazar when he was coming out from the...
You have taken an alibi plea. Alibi. Successful. Failure.
But my lord, through the independent witness that is not supported or anything they have
Independent witness was not examined.
no time and again they have the court issued the summons and the last chance also given, but no report they have produced before the court. as to why these persons were not examined. Only the PW3 is the witness who present at the spot, everything he has done and everything he has completed. Apart from him, there is nobody to
Is
witness.
it fatal
Though it is not fatal, but
regarding a non-examination?
but lordship,
of-
to establish their case beyond reasonable doubt, these witnesses, they must have to examine lordship. The punishment is so stringent.
Is it fatal or not fatal? It depends on case to case.
Yes, depends on case to
It is
case.
not a settled proposition, perhaps,
Lordship.
if I remember correctly, that non-examination of the independent witness is fatal to the prosecution case
Like-
in an DPS.
Lordship. But
Is it settled that
it is.
no examination of independent witness? Acquittal.
In some, depends upon the facts and circumstances.
Depends upon the.
Because this case only depends upon the PW3.
Huh?
PW3, there is nobody. So his statement should be corroborated with the other independent witnesses because lordship, in Bharat Ambale case also we have found, in Bharat Ambale case which has been decided recently regarding this compliance of 52 and all.
So
Mm.
what is your ground here? What are the provisions which are not independent witnesses?
First independent witness lordship.
Okay, one
That-
minute. Independent witnesses. Not examined, okay.
And then lordship, 52 not complied.
52.
A list of
52
samples.
52A.
52A. List of samples not prepared as per these provisions. lordship.
Yes.
Then lordship, this contrabands, whether they kept in safe custody or not, till production of the contrabands before the trial court,
According to you, contraband is not kept in safe custody.
lordship. Because in the packets, there is no seal and it is mentioned signature of the, it is, though it was in seal condition, but Godown incher seal is not there. And the accused signature, exhibit kora hai? Nahi kora na? Accused signature is also not exhibited.
For that purpose, you open the bag in the court.
No, because, not because
Huh?
of that, because the
Because of what purpose?
color is different in this, it is mentioned.
For color.
Color is there, yes.
Bag was
In
open for
dark,
color.
dark browny color and
So bags were open for color.
color and deep brown color.
What is your contention for that? Which is deep brown?
Deep,
After opening, deep brown.
after opening, there is dark browny sticky substance
After
inside.
opening?
Dark brown sticky,
After opening. Dark
brown
brown. Okay, before opening?
before opening deep brown color as per inventory lordship.
Before opening.
I will
Deep
correct-
brown.
Deep. I
So
will-
what is the difference between deep brown and dark brown?
And sticky lordship, there is deep, sorry, dark brown sticky.
Dark brown sticky, that is by the court.
That is by the court. And
Ah.
earlier only deep brown color.
Okay, what is deep brown and dark brown?
There is no sticky materials
No,
also.
no, what is
Yes,
deep
ma'am.
brown and, because I'm not knowledgeable about deep brown and dark brown.
Lordship. I'll explain.
Find out
Lordship.
deep brown and dark brown.
Lordship. She will take time.
We'll see whether, how much time. Otherwise, we'll hear it on another date. Many issues may come up, which may need clarification also. At least next two item, somebody should be there. Yes.
Lordship want to see this brown color and
Which is brown color?
Lordship kindly turn to this inventory,
Inventory,
case number 2224.
224.
224.
Hmm.
In 224 Lordship, it is written the package P1 to P6
Hmm.
contains deep brown color powder believed to be opium.
224.
Powder. And in port, sticky substance has been produced.
Believed to be morphine.
Yes,
This is one.
this is one. That is why
And the other one,
only because of,
brown color believed to be
Sticky.
opium.
yes,
Huh.
powdery substance, Lordship.
Powder.
Then in deposition, it is clearly stated on opening before the court, it is
Where is that
stated
page?
page 333.
Page 33.
Lordship will find in second line, the packet is covered with white marking cloth and a label pasted over the same, and it was found into properly sealed condition. After opening the packet, it is found that there is dark brown sticky substance inside the packet. Because of that reason, these packets were opened before the court.
Hmm.
They produced before the trial.
So what is your submission?
My submission in this
Deep
regard.
brown, dark
No,
brown?
no, not on that. Powdery substance and sticky substance.
So what is the implication?
Implication is that they have collected sticky substance, but they have produced before the magistrate first time, and as per inventory, Lordship,
Then why,
that is powdery substance.
why there should be doubt?
Powdery substance and sticky substance.
So whether you have to scientifically submit
Yes.
that opium, if it is in powdery form, cannot become sticky. We are not scientists.
Hmm.
Seal, court has found it is seal. Whatever. Court's opinion,
Court's opinion.
court's view is that.
To
Right?
that regard,
So you have to submit
yes,
on,
yes.
on the strength of some
Lordship,
basis.
Lordship,
There has to be some foundation.
they have
The powdery and sticky.
powdery,
So
powdery.
trial is vitiated. That cannot be
No,
a
no, no,
submission.
that cannot be the ground, alone the
You
ground.
have to be,
Lordship,
make your submission on the
powdery,
strength of some basis. And
yeah,
normally it should be scientific.
though it was in seal condition, Lordship, after search and seizure, they have stated that that was deposited in the godown. As per section 55, Lordship, it is the duty of the official godown in charge to receive the affixing his own seal over there, over the seized contraband. That is not there as per the depositions, Lordship. Clause.
55, let us see.
Before that, Lordship kindly peruse section
So you have
50
taken me to 55, let us see 55.
before that, Lordship, kindly peruse section 52. In 52, Lordship, it is the duty of the officer if any person arrested, any officer arrested,
52.
only 52. Any officer arresting a person under section 41, 42, and 43 or 44 shall as soon as may be inform him of grounds for such arrest. Every person arrested and article seized under warrant issued under subsection 1 of section 41 shall forward with unnecessary delay to the magistrate by whom the warrant was issued. Every person arrested and article seized subsection so and so and so shall forward without unnecessary delay to the subsection 3. In here it is mentioned the officer in charge of the nearest police station and the officer empowered under section 53 is forwarded and to as per this to the empowered officer also or officer in charge. The authority or officer to whom any person or article is forwarded under subsection 2 or subsection 3 shall with all convenient despatch take such measures as may necessary for disposal. Then Lordship 55. It is clearly stated an officer in charge of a police station shall take charge of and keep in safe custody pending the order.
Let us see 53 first.
53, the empowered officer, power to invest. Power to
So
invest.
here is a case where office, not officer in charge, empowered officer.
Empowered officer first. That is the godown in charge. The central government, after consultation with the state government, may by notification publish in the official gazette invest any officer of the Department of Central Excise, Narcotic Customs, Revenue Intelligence, or any other department of the central government, including paramilitary forces or armed forces, or any
Okay.
class of such officers with powers of an officer in charge of police station for investigation of the offences under this act. The state government may by notification publish in the official gazette invest any officer of the Department of Drugs Control, Revenue and Excise, or any other department or any class of such officers with the powers of an officer in charge of the police stations for the investigation of the officer under this act. Then 55. In 55, a police to take charge of articles seized and delivered. An officer in charge of a police station shall take charge of and keep in safe custody, pending the orders of the magistrate, all articles seized under this act within the local area of that police station and which may be delivered to him, and shall allow any officer who may accompany such article to the police station or who may be deputed for the purpose to affix his seal to such article or to take samples of and from them, and all samples to take shall also be sealed with a seal of the officer in charge of the police station.
Okay, let us see PW2 then.
PW2 is the insurance,
Hmm.
page 4.
Yes.
On 6/5/2016, I was working as superintendent in Narcotic Control Bureau, Guwahati. On that day, one Pawan Vaisane, intelligence officer, NCB Guwahati informed me in writing that 2 parcels, namely so and so and so, were going to deliver a consignment of morphine and opium to the other parcels, namely Saurabh Khan and Ramin. The place of delivery of the consignment was near entrance of Sorsosa Stadium, Guwahati. The time of delivery of consignment was 7 a.m. on the next day. After receiving the information, I acknowledged the signature of the intelligence officer and forwarded the information to our General Director NCB at Guwahati office. After receiving the secret information, the General Director Praveen Kumar issued an office order on 6/5/2016, directed some of the officers and sepoys to proceed to Indira Gandhi Stadium, Lohra, Guwahati for the purpose of search and seizure of narcotic drugs, and it is intimated that in the case of narcotic substance of the case will be so and so and so, and Sri Pawan Vaisana will be the seizing officer. Exhibit 3 is the written down information NCB 1. Then I know the signature. Then Exhibit 4 is the office order issued Pawan Vaisane, Zonal Director NCB. Uh, I also know, I also, I was the uh, in charge of NCB Godown, and on 7/5/2016 at about 5:45 p.m. Sri Pawan Vaisane, seizing officer, came to me along with the seized item and samples of the seized items. He handed over those samples and articles to me and Godown in charge. I kept all items and samples in the Godown of the NCB and issued a Godown receipt through Pawan Vaisane. Exhibit 5 is the Godown receipt. On 8/5/2016, again, Pawan Vaisane received back the seized items and samples for taking into the court for the purpose of showing those seized articles to the court. Exhibit 6 is the Godown receipt number 2. On that day, on that very day, that is on 8/5/2016, after producing of the seized items and samples in the court, Pawan Vaisane returned it back to me, for which I issued NCB Godown receipt number 3. Then Exhibit 7 is the said receipt. On 9/5/2016, Pawan Vaisane received the original samples from me for sending those samples to FCL Guwahati. Then Exhibit 8 is the Godown receipt number 4. On that very day, Pawan Vaisane submitted compliance report under Section 57 of NDPS Act. Exhibit 9 is the said compliance report submitted by Pawan Vaisane. I was in the search team on 7. I was not in the search team on 7/5/2016 when Pawan Vaisane produced the seized articles and samples to me. They also brought the 4 accused persons to the officer. I saw their faces. Then cross. In Exhibit 3, no reference number has been given. I acknowledge the confirmation, and after making it, I forwarded it to the Zonal Director, and I did not give separate forwarding letter. Neither me nor Pawan Vaisane or the Zonal Director put their official seal in Exhibit 3. It is not a fact that 6/5/2016 at about 5:30 p.m. or any time we did not receive any information. Exhibit 4, there is no seal of Zonal Director. Exhibit 4, the name of the accused persons have not been mentioned, and the name of the contraband item are also not mentioned in Exhibit 4. In Exhibit 5 to Exhibit 7, I received 6 sealed packets marked as P1, P2, P4, P5, and P6 containing so and so opium respectively. I also received 1 sealed packet marked as P7 containing 2.5 kg of morphine. In Exhibit 7, facsimile of the seal is absent. Then I received 2 yellow envelopes. One envelope contained documents and other envelope contained currency, and I mentioned the same in my Godown receipt as because those were unmarked. I did not receive any other articles, documents, and currency beyond things mentioned in Exhibit 5 and 7. I put my signature only in the first page of the compliance report submitted by Pawan Vaisane under Section 57 of NDPS Act. I did not receive any extra forwarding letter with a report under Section 57 of NDPS Act. It is not a fact that I did not receive any information on 6/5/2016. It is not a fact that as on 7/5/2016 in the morning, the accused persons were arrested. It is not a fact that the accused Saurabh Khan and Ram Milan have been arrested on 6/5/2016 from Sultan Bazar. It is not a fact that after arresting the accused person 6/5/2016, we implicated therein this false case. It is not a fact that in Exhibit 3, a manipulated document. It is not a fact that I am deposing falsely at the interest of officer. It is not a fact that accused persons are not involved in this case. At the time of receiving articles, we maintain Godown register. I have neither seen the Godown register in the court today nor any copy of the Godown register was submitted in the court. So then, for other two,
Which part is material?
Lordship,
Which part of it is material?
material part, Lordship, the
Which part?
contraband which was kept in her custody, that was not produced before, like the PW3.
Which
There-
part? Which part?
It is not mentioned in her deposition.
What?
The material exhibited before the trial court by the PW3, which was in her custody. In the material, there, as per section 55, her seal and signature is required. Yes.
Where says he has
She has
said-
not stated in any way.
Did you ask?
She has not stated, that is.
Did you ask
My lord-
anything? I am asking you the question.
Lordship,
Did you ask?
we did not ask because she did not
Good
state it,
enough.
that is why,
Good enough.
Lordship. Because material not before the court on that point of time.
Which one?
Material.
No, it is
whichever-
the Godaam receipt.
No, all
No,
the seals.
which part of this testimony of PW2 is material for the defense? That is what I am asking. You have read. To point out which one.
My
so
lord,
that we
Godown
can
register is
examine.
there. Godown register, she has.
Which
mentioned.
part? Which part?
Eight, page 8.
Page?
Page 8, last. She issued Godown receipt. Last 3 lines.
Hmm.
At the time of receiving articles, we maintain Godown register. I have,
Page 8.
yes, inner page 5.
Which page? First line or what?
Last 3 lines before the cross.
Last 3 line.
At the time of receiving articles, we maintain Godown register.
Huh.
I have neither seen the Godown register in the court today, nor copy of the Godown register was submitted in the court because he has issued receipt of Godown.
Hmm.
So it was the duty of the officer to produce the extract copy of the Godown register, where she has maintained. Because she kept, as per section 55, she kept all the articles in her deposition. She has stated all the seized articles deposited to her under her search. So it was her duty to prove that these were the goods, and I put my seal here, her own seal, lordship, Godown interest seal. That was not there. That is why while this material seized goods exhibited before-
Where have you questioned that you did not put your seal?
in PW3.
Huh?
PW3 in a cross, lordship, as cross page at page 25.
Huh?
Page 25.
Yes, 20.
Hi.
5.
First,
No, did you ask this Godaam in charge?
because lordship.
No, please,
Lordship.
please,
Lordship.
don't test
Lordship.
the court.
Lordship.
When I asking a query, be patient with it. Where did you ask this aspect to PW2? Where did you ask? In your cross.
In our case, it is not there, lordship, like.
That is what I have asked.
Because lordship,
My specific question is that where did you ask PW2?
no, lordship,
Because she was the Godaam in charge.
lordship.
So if she has been entrusted with the duties under section 52, 53 and 55, then she has to be put for cross-examination on that aspect,
lordship.
not to somebody else. This is one of the vital aspect
Yes.
in a trial.
Yes.
So where did you ask her?
We did not, my reply to that regard, lordship.
No, I have said,
Yes.
your reply I am not asking. I am asking, where did
We
you
did not
ask?
We did not ask.
That is what I have asked.
Yes, lordship.
Be specific to the question.
Lordship.
Yes or no? If yes, which part?
No, Lordship.
That is I have asked.
Regarding material, we did not ask.
That is what I have asked. Be specific
Lordship.
in your answer.
Yes.
Not here and there, PW7, PW2, PW.
No.
Is
I'm not-
other than PW2, don't take me to others. When I ask a specific question.
To PW2, that question
Yes,
was.
that is what I have asked.
Yes.
Be specific.
Lordship.
Otherwise, you are at liberty to make submission. But when I ask a question, be specific in your answer. Am I clear?
Lordship.
Then. So you did not elicit regarding 55 from PW2.
From PW2. And PW2 also did not state it in anywhere that she has received and put her seal over the seized material which was produced, which was deposited to her. She has also not stated in her chief.
Yes. How 55 is not complied with?
Ma'am.
You have taken us to page 7. page seven, you said that in exhibit seven, the facsimile of the seal is absent. I think that is what you said.
The simile of the seal is in exhibit 7 is absent.
Absent. And what more? Gudam register.
Yes.
And
And in the material exhibit, which was exhibited by the seizing officer.
no, we are considering a
PW2.
PW2
Lordship.
with regard to 53, 54,
Yes.
52, 53 and 55.
Lordship.
You made submission on that.
Yes.
So 55, how it is not complied with? That you said, na, you read to affix his seal to such article or to take samples of and from them, and all samples so taken shall also be sealed with the seal of the officer in charge of police station. But you did not ask anything on 55. I did not find anything. To PW2 with regard to 55 specifically. Such a to take samples of and from them, and all samples so taken shall also be sealed. The seal of the officer in charge. No, you did not ask anything.
No, Lordship, I
It
want,
is completely silent.
but Lordship,
I read entirely.
I would like to, I would like to show one more thing, Lordship, here in page number 5, Lordship. In paragraph number, third paragraph, fourth paragraph, no? Fourth paragraph. No?
Hmm.
It is the prosecution case, Lordship, my humble submission to that regard.
No, which
Yes.
way, which?
In paragraph number
Page
4,
five.
page 5,
Hmm.
paragraph number 4. Here she has stated, I also, the in-charge NCB go down and on 7/5 at about 5:45 PM, Sri Pavan Vaisana seizing officer came to me along with the seized item and sample of the seized items. He handed over those samples and articles to me, and as godown in charge, I kept all those items and samples in the godown of NCB and issued godown receipt through Sri Pavan Vaisana. She has not stated in her deposition that I received and I put my signature or seal over the all
If you
the
read 55,
with
that does not require her signature.
seal, F to affix seal, Lordship.
What is seal?
Her own seal, Budan Inch's own seal,
It
Lordship.
is there.
It is not. Material exhibit exhibited. No, Lordship, in materials 1, 2, 3, 4, 5, 6, and 7. These are the contrabands. In
Receipts are exhibited. Not 1, 4, 5.
no, receipts. Receipts,
Down receipt.
go down receipts are exhibited as Lordship. Exhibit 4, 5, 6, 7. And I would like to show the material exhibit.
No, which one? 5, 6, 5, 7, and 8.
Material exhibit 1, 2, 3, 4, 5, 6, and 7. That is produced or exhibited by seizing officer, Lordship. In those,
No, page 5.
yes,
Page 5 is not dealing with material exhibit. Please try to
yes,
understand.
yes, it is not dealing with the
Ah,
material.
why
exhibit.
then you are taking us to?
I would,
material? Why you are pointing us to paragraph 4?
yes,
What is the reason for pointing out?
Lordship, go down in charge, receive all the things,
Huh.
all the seized material and samples.
Huh.
Then as per section 55, after receiving, Lordship, it is the duty of the in charge to, after taking all these things, to maintain this, Lordship. An officer in charge of police station shall take charge of and keep in safe custody pending the orders of magistrate all articles is under this act
Hmm.
within the local area of police station and which may be delivered to him and shall allow any
This
officer.
this part is comma,
Yes,
right?
yes.
What is wrong?
Then
What
next,
is wrong? First part.
seriously,
There are 2 parts to it.
yes,
55.
yes,
An officer in charge of a police station shall take charge of and keep in safe custody,
yes,
pending the orders of the magistrate, all articles seized under this act within the local area of that police station, and which may be delivered to him. Then comma.
comma,
This part is one part.
yes.
Now come to paragraph 4 of page 5.
She received,
What is wrong?
yes.
What is wrong?
There is no wrong, but she has not stated.
If there is no wrong,
No, but she has lot second part.
uh, tell me.
Second part she
Ah.
has not complied with.
Second part is taking out of sample by that officer, seizing officer.
Shall allow any.
Then shall allow the officer in charge, that 53 empowered officer, shall allow any officer who may accompany such article to the police station, meaning thereby PW3,
Yes,
right?
Yes.
Please try to understand.
yes,
Or who may be deputed for the purpose.
yes.
Instead of PW3, the other can be also allowed.
No,
Deputed
Deputed other,
to affix his seal to such article or to take samples out and from them. And all samples so taken shall also be sealed with a seal of the officer in charge of a police station. There are 2 parts to it.
Yes,
One is
first-
depositing. One is depositing to the empowered officer or the officer in charge.
Yes.
That ends with the comma in fourth line. Thereafter, shall allow. After depositing, he can allow. What are the procedure to be followed while allowing to take out the sample
From the
or
Godam.
material, Godam, that is in the second part.
Second part.
So you have been pointing me to paragraph 4 of page 5.
Yes, here she has.
What material irregularity was there?
After receiving, it was exited.
You concentrate on the exit part. Entry part, what is wrong?
Entry she received. After that, it is in her custody.
Right.
After that, she has deport PW3 to produce these things before
That
the
part you concentrate, whether in the first part there is any material irregularity.
No, there is no irregularity.
Then why you are taking us to,
Taking this because she has not stated on while she has exited or deported PW3 to produce all the materials before the court. They affix her she affix her seal over this seized contraband. That is
what
not there.
that,
She has
on
not.
that point I have
Yes.
asked you,
Yes,
right?
yes.
That did you ask her?
No, we did not ask because she has. It is their case,
Ah.
Lordship. That is why
That is their case, that is a different thing.
prosecution first.
In the appellate stage, you are in appellate stage,
Yes,
not
but-
in the trial stage.
Yes.
So did you ask? No, you also did not ask.
In our process, it is not.
We
there.
have to examine that issue.
Yes.
That is why they have not said. You did not ask. At the same time. Am I correct?
Yes.
So this is the position.
We ask when it produced before the court. We ask when it is.
We'll
produced.
look into that. But so far PW2 is concerned, you did not ask.
Yes,
We are presently concentrating on PW2.
yes, yes, yes,
You did not ask also, right?
yes,
On section 55, compliance of section 50.
yes.
They also did not say anything. You also. And all these packets are also not before us.
Yes. Or that,
Those
while
packets, samples are also not before us,
Yes,
right? Material exhibits are not before us. We are on the document part. We have seen the Godam receipt, exhibit 5 to 8,
yes.
right?
Mm.
Okay. What irregularity you have brought out from PW3?
In PW3, in page 21,
Hmm.
materially exhibited.
He said in page 19. What is exhibit 7?
This is go down received.
Exhibit 7. Exhibit 7.
Exhibit.
What is exhibit 7?
Exhibit seven.
PW's,
Yes. 3.
PW2, what she said, PW2. On the very day after producing the seized item and sample, okay, PW6, it should be PW6. On 8/5/2016, again, Pawan Baisne received back the seized item and samples for taking into the court for the purpose of showing those seized article to the court. Exhibit 6 is the Godam receipt, right?
Yes,
He took out the things, articles,
yes.
white exhibit 6
Mm.
on 8/5/2016. Now let us see what he said about exhibit 6,
PW.
PW3.
PW3. In page number 27,
Now what he said in chief,
chief.
Cross part.
In first part, page number 27. Third paragraph.
Is number
27, third paragraph.
27. $27. Okay. What is this? Which line?
In 27, in exhibit 6, Godown received numbers 6, 7, and 8. There is no mention of depositing the plastic bag in the godown along with the contraband packets. The memo number, which is mentioned in the sample packets, was not mentioned in the test memo. Test memo.
So what do you intend by that? It's a deposited plastic. If you go to exhibit 6 sealed packets wrapped with white marking cloth. Because above the plastic packets, white marking cloth marked as P1, P2, P3, P4, P5, P6 containing 10 point so and so, 10 point so and so, 10 point so and so, 10 point so and so of opium respectively. One sealed packet wrapped with white marking cloth marked as P7 containing 2.07 kg of morphine. So over the plastic bag that was wrapped by marking cloth. So how does it improve your case? Just because it is not mentioned plastic bag?
Lordship, in page number 12. It
So,
is mentioned, it is mentioned.
When you concentrate on 27, you should
Because-
concentrate on 27.
Because,
Oh, what you have derived from page 27?
Lordship,
Paragraph 4.
it is alleged that
No, no.
as
I am
they have
going
said,
one by one.
yes, yes.
When I go to 27, you go to 12. When you go to 12,
No, I want.
when I go to 12, you go to 25.
27.
I am slow in understanding, right? So what can you derive from this? In exhibit 6, the Godam receives 6, 7, and 8. There is no mention of depositing plastic bags in the Godam along with contraband items. Because if I am correct, you have opened the bag there, trial code. It was wrapped in marking cloth, all these plastic bags. Right? If something is covered, plastic bag is covered by marking cloth and sealed, there may not be any mention of plastic bag. It will be marking cloth seal bag, right? It could be. So what advantage you can derive from this part of cross-examination? That is what I am asking.
Lordship, actually.
You have taken me to this point.
Yes. Because regarding exhibit 6, the question is there. That is why, Lordship, yeah, here, at the time of interception, the person intercepted with the plastic bag, which was carried, and this was carried, the contrabands were carried, and the plastic bags were in their hands. It is stated in the deposition also in page 12. That is why this question was there, where they have kept this plastic bag, where the contrabands were kept.
So your main point is plastic.
No, if it was not in my hand directly, it was carried in a plastic bag, Lordship. Whether that was seized, mentioned in the seizure list, and it was deposited, because what I found in the authorities, in some authorities, that Lordship, whatever found in the at the time of seizure, everything must have to seized and produced before the court. And one more thing is that test memo number, which is mentioned in the sample packet, was also not in the test memo. Itu kode sini. The memo number. Itu gudang test memo. And then material exhibited before the court by the seizing officer. In material exhibit 1 to 7. Here also he has not stated that the signature of the in charge was there.
So did you ask him?
Yes.
Did you ask?
Yes.
Okay. Which part?
In page number 25. First two lines.
Okay. Now, again read 55. 55, second part. Second part.
Shall allow any officer who may accompany such article to the police station or who may be deputed for the purpose to affix his seal to such article.
This is one part.
Yes.
To who may be deputed for the work to affix his seal
Mm.
to such article. Being thereby PW3.
PW3.
Right, next part.
or to take samples of and from them, and all the samples should taken shall also be sealed with the seal of the officer in charge of the police.
Where is that part of taking sample? Article is different, sample is different.
Yes,
So how 55 is not complied?
samples which,
You have to read the provision part by part as a whole also.
yes,
So far as taking out the article is concerned, it is the officer who takes out. He has to put his seal. And allowing him to take samples, then he has to put the, or Godown in charge has to put the seal. If you read minutely, subject to correction. This is my understanding, prima facie. My understanding, prima facie, and just reading the provision only. So you have to make me understand.
yes, Lordship, shall allow any officer who may accompany such article. To my understanding, Lordship, as per section 55, after search and seizure, duty of the seizing officer to deposit to the
So
in
there
charge.
is disagreement. Show us some authority then. That will cleanse the issue. Wiser man deciding the issue, right?
Yes, Lordship.
Ms. Nargis, to take samples of and from them, right? From them means the articles. To take samples of and from them. Them is the article, if I have understood correctly. Then all samples so taken shall also be sealed with a seal of the officer in charge. The word dam has significance.
But then where to collect the samples?
Amle? Amle has answered. Amle or Kamle?
Parathambal.
Huh? There is. If it takes that sample in front of the Godam in charge and he has to put the seal. That is the third way maybe, I don't know. But my understanding of the English here is that. Your
But
understanding
that
is
is-
different, so show us some authority.
To that regard, Lordship.
55,
55 is there.
part by part.
My lord, if regarding collection of samples, it is clear in the section 55A. 55A,
We'll-
except this,
no,
there
no.
is No, there's no sections inserted under NDPS Act.
Go on, then. What more?
No, if we go by this, if Lordship has mentioned, Lordship, that samples if taken in presence of the officer in charge. But section 52 is quite different.
Okay. Page 55, the first part of the cross-examination,
Yes,
we tried to understand this submission in relation to 55,
yes,
because, see, Ms. Nargis,
yes.
first you took us to page 27, paragraph 4. We are not finding any merit. In exhibit 6, the godown received 678, there is no mention of depositing plastic bags. I am saying it clearly. Right? This plastic bag. Now you have taken us to page 25. First part, first 2 lines. That this is contravention of section 55. Right?
Yes.
Your submission is that
See, go down.
in
to-
material exhibit 357, there is no signature of any seal of the Godam in charge of NCB, and Godam entry number so and so is not mentioned in 357. This is clear contravention of section 55. You have said. So your understanding is one. My tentative understanding is one, different. On that. So anything else?
In, yes, Lordship.
Ah,
And regarding samples. Bharat Ambale Lordship.
let us see. How the-
Lord, Bharat Ambale.
Make submission,
Yes,
keeping in view that original packets, 7 packets, that means the primary evidence was produced before that. Keeping that in mind, you make submission on 52A. Huh? Huh?
it is reflected in the deposition also. No, it is reflected in the deposition also.
Uh-huh.
No.
No, it is there. I have already read it.
The Learned Council of the accused Saurabh Khan Rammilan has submitted a prayer for
Page 33.
judgment.
Page 119, paragraph 37.
Come to page 33.
No, it is written there, but without the request of the council.
Page.
Page 33.
No, that I have read. Which paragraph, Mr.?
37.
Where it starts.
Page 119, paragraph 37.
That is same to paragraph 33.
Yes. Paragraph 33, so page 33,
Ah.
third paragraph. Again, so I could business.
They are the powdery and sticky. That is their submission. Yes.
In Bharat Ambale case, Lordship, it is mentioned that 52A is not be the alone ground for allowing a petition. Here some, after threadbare discussion in this case, like the other cases, Jurarpura, Mangilal, Muhammad Khalid, all this, and Noor Aga, all this have discussed here in this case. So in this case, Lordship, it is stated in paragraph number, it starts from paragraph number 22.
Any case where physical evidence was not produced or produced? Any case, many cases have been cited, right?
Yes.
Any case where physical evidence was produced, in spite of that, non-compliance of section 52 has vitiated the trial.
Paragraph 30,
30.
paragraph 30. May it's
Hmm.
thus, from the above, it is clear the procedure prescribed by standing orders or rules in terms of section 52A of NDPS Act is only intended to guide the officer and to ensure the fair procedure is adopted by the officer in charge of the investigations. And as such, what is required is substantial compliance of the procedure laid therein. We say so because due very circumstances, there may be situations wherein it may not always be possible to forward the seized contraband immediately for the purpose of sampling. This could be due to various factors such as the sheer value of the contraband and the peculiar nature of the place of seizure, or owing to the volatility volatility of the substance so seized that may warrant slow and safe handling. There could be situations where contraband after being sampled cannot be preserved due to its hazardous nature and must be destroyed for forthwith, or vice versa, where the nature of the case demands that they are preserved and remain untouched. Due to such multitude of possibilities or situations, neither can the policy be realistically expected to rigidly adhere to the procedure laid down in section 52A or its allied rules or orders, nor can straitjacket formula be applied for insisting compliance of each procedure in a specific timeline to the letter due to varying situations or requirements of each case. Thus, what is actually required is only a substantial compliance of the procedure laid down under section 52A of the NDPS Act and standing orders or rules framed thereunder. And any discrepancy or deviations in the same may lead to the court draw an adverse inference against the police as per the facts of each and every case. When it comes to the outcome of trial, it is the only after taking cumulative view of the entire material on record, including such discrepancies, that the court should proceed either to convict or acquit the accused. Non-compliance of the procedure and wishes under section 52A may be fatal only in cases where non-compliance compliance goes to the heart or root of the matter. In the other words, the discrepancies should be that it renders the entire case of the prosecution doubtful, such as instances where there are significant discrepancies in the color of description of the substances from the indicated in the FSL report as was the case in Noor Agha, or where the contraband was mixed in or stored in some other commodity like vegetables, and there is no credible indications of whether a narcotic substances was separated and then weighed as required under standing orders or rules, thereby raising doubt over the actual quantity seized, as was the case in Muhammad Khalid, or where the recovery itself is suspicious and uncorroborated by witnesses. As in Mangila, in our case also, we corroborated with this, or where the bulk material seized in contravention of section 52 was not produced before the court despite being directed to be preserved, etc. These illustrations are only for the purposes of bringing clarity on what may constitute as a significant discrepancies in a given case, and by no means is either exhaustive in nature or supposed to be applied mechanically in any proceeding under the NDPS Act. It is for the courts to see the constitutes as a significant discrepancy, keeping in mind the peculiar facts, the material on record, and the evidence adduced. At the same time, we may caution the courts not to be hyper-technical whilst looking into the discrepancies that exist, like slight differences in weight, color, and numbering the sample. The court may not discard the entire prosecution case looking into the discrepancies, as may often than not an ordinarily an officer in a public place would be carrying a good scale with him as held Nuraga. It is only those discrepancies which particularly have the prosperity to create a doubt or false impression of illegal possession or recovery or to overstate or inflate the potency, quality, and weight of the substances that may be pertinent and not mere clerical mistakes provided they are explained properly. Whether a particular discrepancy is critical to the prosecution's case would depend on the facts of each case, the nature of substance seized, the quality of evidence on record, etc. At the same time, one must be mindful of the fact that Section 52 of the NDPS Act is only a procedural provisions dealing with seizure, inventory, and disposal of narcotic drugs and psychotropic substances and does not exhaustively lay down the evidentiary rules for proving seizure and recovery, nor does it dictate the manner in which evidence is to be laid during trial. It is no manner prescribes how the seizure and recovery of the substances is to be proved and what can be laid as evidence to prove the same. Rather, it is the general principle of evidence enshrined in the Evidence Act that governs how seizure or recovery may be proved. Then, in 32, the prosecution says the compliance of the procedure section 52 of NDPS Act will not render itself helpless but can still prove the seizure and recovery of contraband by leading cogent evidence in this regard, such as examining the seizing officer, producing independent witness in paragraph 32, madam. The examining the seizing officer, producing independent witness to the recovery or presenting the original quantity of seized substances before a court, the evidentiary value of this material is ultimate to be assessed and looked into by the court. The court should consider whether the evidence inspires. The court should look into the totality of circumstances and the credibility of the witnesses, being mindful to be more cautious in their scrutiny where such procedure has been plotted. The cumulative effect, all the evidence must be considered to determine whether the prosecution case has successfully established the case beyond a reasonable doubt as held in Nuraga. Even in cases where there in non-compliance with the procedural requirement of Section 52A, it does not necessarily initiate a trial warrant or warrant an automatic acquittal. Courts have consistently held that procedural lapses must be viewed in the context of overall evidence. If the prosecution can otherwise establish the chain of custody, corroborate the seizure with the credible testimony, and prove its case beyond reasonable doubt, the mere non-compliance with 52 may be fatal. The emphasis must be substantive justice rather than procedural technicalities, and keeping in mind that the solitary objective of the NDPS Act is to curb the menace of drug trafficking. At this stage, we may clarify the scope and purport of Section 52F, Section 4, with a view to obviate any confusions of Section 4 of Section 52A, provides that every court is trying an offense under NDPS Act shall treat the inventory, photographs, and samples of the seized substance that have been certified by the magistrate as primary evidence. It is lacking in our case. So thereafter, this honorable court 37. Paragraph number 37 is stated that Section 52A of the court should not be conflated as a rule of evidence in the traditional sense. That is, it should not be construed to have laid down that only the certified inventory, photographs, and samples of the seized substance will be primary evidence and nothing else. The rule of primary evidence or best evidence is now well settled. In order to prove the fact, only the best evidence to establish such fact must be laid and adduced, which often happens to be the original evidence itself. The primary evidence for proving possession will always be the seized substance itself. However, in order to mitigate the challenges in preservation of such substance till the duration of trial due to pilferage, theft and degradations or any other related circumstances, the legislature consciously incorporated subsection 4 of section 52A to bring even the inventory photographs or samples of such seized substances on the same pedestal as the original substance, and by deeming fictions has provided that the same be treated as primary evidence, provided they have been certified by a magistrate in substantial compliance of procedure prescribed. This, however, does not mean that where section 52A has not been complied, the prosecution would be helpless and cannot prove the factum of position by adducing other primary evidence in this regard, such as by either producing the bulk quantity itself or examining the witness to recovery, etc. What Section 52A of subsection 4 of NDPS Act does is it creates a new form of primary evidence by way of deeming fictions which would be on par with the original seized substance as long as the same was done in substantial compliance of the procedure prescribed thereunder. However, the said provisions by no means renders the other evidence in original to be excluded as primary evidence. It neither confines nor restricts the manner of proving position to only one mode. That is, through such certified inventory photographs or samples, such that all other material are said to be excluded from the ambit of evidence. Rather, it can be said that provisions instead provides one additional link of evidentiary role in proving such position. Thus, even in absence of compliance, courts cannot simply overlook the other present evidence in the form of the seized substance itself or testimony of witnesses examined. All that would be required in the absence of any such compliance is to be more careful while appreciating the evidence. In the present case, the only ground has been canvassed by the appellant here is that section 52A of the NDPS Act and the Rule 10 of NDPS Rules 2022 had been contravened in as much as the investigating officer had allegedly mixed all the 73 packets of seized contraband together and thereafter proceeded to draw samples and injunction. This, according to the appellant, renders the accuracy and reliability of samples as doubtful. Sure. Then in 48, it has been discussed. Honors, we are conscious of the fact of this court in Mangilal held that in a given case, the onus would be on the prosecution to satisfy the court as regards the compliance with mandate of section 52 of NDPS Act. Onus upon the prosecution. So it is mentioned that before a Mangilal here referred, before any proposed disposal or destruction mandate of section 52A, NDPS Act requires to be duly complied with, starting with an application to the effect a court should be satisfied with the compliance while deciding the case. The onus is entirely on the prosecution in a given case to satisfy the court when such an issue arises for consideration. Production of seized material is a factor to establish seize, followed by recovery. One has to remember that the provisions of the NDPS Act are both stringent and rigorous, and therefore burden heavily lies on the prosecution. Then 49 also, it is mentioned, Rashid, last one. However, a close reading the aforesaid decisions reveals that this onus on the prosecution will only encumber once such an issue of non-compliance arises for consideration. Although we are in complete agreement with the aforesaid observations as much as it would be for the prosecutions to establish and prove compliance of section 52 of NDPS Act, yet at the same time we are of the considered opinion that mere assertion by the accused that there has been non-compliance of the said provisions may not be sufficient. The initial burden will always be on the accused to lay down the foundational facts for establishing that there has been a non-compliance of section 52A of the NDPS Act, either by leading evidence of their own or by relying upon the evidence prosecution itself, such by putting direct or specific questions to the police officer and key witnesses. Such burden on the accused to establish contravention of Section 52A of NDPS Act will only be on the mere preponderance of probability where once foundational facts are established that raises and issues as regards the non-compliance of Section 52A of the NDPS Act. The onus will entirely on the prosecution to prove by the cogent evidence that either there was substantial compliance with the mandate of Section 52 of NDPS Act or satisfy the court that such non-compliance does not affect its case against the accused and the standard of proof required would be beyond reasonable doubt. So after summarize, Lordship, in para 2, it is mentioned that although there is no, in 4, no, 2, although there is no mandate that the drawing of samples from the seized substance must take place at the time of seizure held Mohanlal, yet we are opinion the process of inventorying, photographing and drawing of samples of the seized substance shall as far as possible take place in the presence of accused, though the same may not be done at very spot of seizure. So in this case, it is the duty for compliance of this Section 52A lies upon the prosecution. They have to establish that they have followed this rule.
What is two?
2 is, Lordship, summarize section
Summarize two.
2. Although there is no mandate that drawing of sample from the seized substance must take place at the time of seizure as held Mohanlal, yet we are opinion that the process of inventory, photograph and drawing of sample of the seized substance shall as far as possible take place in the presence of accused, though the same may not be done at the spot. Here is
No,
what-
here is a very spot of seizure according to them. Right. That sampling,
yes.
trial of sample was at the very spot of seizure. So prosecution case falls in two. Suppose it is correctly done, drawal of sample. Let us assume for a moment. If it is correctly done, the seized contraband material exhibits were produced before the court. So if that is so, what will be the lacuna in the prosecution case?
Lacuna in this regard, Lordship, on the spot they have collected this is and produced with a court. But procedure laid down in Section 52A that should be prepared, shall be prepared an inventory. And after that, an application should be made to for certification of correctness of that inventory, and then that should be certified by the magistrate, and the list of samples should be prepared by them. That is not done in this case, and it is the
Madam Nargis, you find out this Bharat Ambale has considered many issues. The question is, assuming for a moment, all this powder is sticky, leave aside that. For the moment, you leave aside that powder is sticky business.
Lordship.
If the original contraband packets are produced, and secondly, the trial of sample from the alias contraband took place at the very place of seizure. And those samples, assuming for a moment, were also produced before the court as exhibits. All the 7 packets and all the 7 samples with the FSLA placed. Non-adherence of 52A. Because subsection 4, if you say, as a whole, if you read the scheme of 52A, if original sample is not produced, original contraband, then as a substitute, the inventory, drawal of samples, and photographs duly certified by the magistrate is to be treated as primary evidence. Am I clear?
Clear.
Subsection 4. So inventory, drawal of sample, and photograph. Photograph means all the packets,
Yes.
right? Now it is a case like a photograph of Nargis and Miss Nargis itself, or virtual and in person. This is the best proof.
Madam.
Nargis through virtual mode or Nargis in person. Nargis in person is better proof than virtual. In today's days of AI, right?
Lordship.
So you are here. You are the best evidence,
That is correct.
right?
Lordship.
So this inventory part, then this photograph. So for subsection
Yes.
4 of photograph goes.
Yes.
Photograph goes. It a very, you yourself is present personally. Photograph is not required, right? There remains 2. One is sample,
Yes.
drawal of sample, certification by magistrate, and the second one is certified inventory. Photograph goes,
Yes.
these 2. Now sample at the spot of seizure. This Amle also says. Mohanlal also. This could be a valid drawal of samples.
At the spot.
Look into it, look into it.
Yes. At
I'm
the
giving
spot.
you time.
Yes, at the spot.
It is not discarding it.
Yes.
Amle is not discarding it,
Yes.
right? Although there is no mandate, see the language,
Yes.
that the drawing of samples from the seized substance must take place at the time of seizure. It can take place later on also. Mohanlal approves it. Drawal of sample at the spot of seizure. Yet we are of the opinion that the process of inventorying, photographing, drawing of samples of the seized items shall, as far as possible, take place in presence of the accused, right? this has at least sampling seizure. Photographing is not required, maybe required, I don't know. Process of inventory, drawing sample. Seizure as far as possible take place in presence of the accused. At least a drawal of sample, it appears to be in presence. Though the same may not be done at the very spot of seizure. Means it is advisable at the very spot of seizure. Otherwise, line was going in a straight line. But Amle has done differently,
In zigzag.
right? It has become zigzag now. Otherwise, right from, it was going in a straight line.
Yes, Lordship.
It has again created some subjective things
Yes.
from the objective manner of appreciation. It has put subjective things now, if I have understood correctly. This para 2, as otherwise it was a very straight line, right from all this Mangilal along.
Yeah.
This is the difficulty. Ambale was relied. You have to look into it. Ms. Nargis will continue on some other.
Lordship.
And what are the other points? Please tell me.
Other points, some regarding
52A.
this, Lordship, at the initial, at the starting of this case, I have pointed out this, this section 32B.
Section 32B, we will keep in mind, but
But Lordship, for that purpose, Lordship look into the merits of the case. And Lordship, one more thing is there. They are the first offender and they have no bad records, Lordship. And one person
that will
is-
come at the last. If you are acquitted,
Lordship. Lordship,
if we were 50-50,
50%.
then we'll look into section 32B,
Lordship.
right?
Lordship.
Otherwise, we don't have to look into
Lordship.
32B,
Lordship.
right?
Lordship.
First offender, okay. No criminal antecedent. And all these are not fulfilled,
Lordship.
32B, according to you, right? I have seen ABCDB, ABCD up to
Yes.
whatever. So 32B will come in last. Any other,
Any other Lordship?
on the other provisions?
Other provision, Lordship, search the authority regarding section 55.
Hmm?
Section 55, I'll place on the next day.
You find out section 55.
And I'll
If something
prepare-
wrong,
Lordship, Lordship, I'll prepare.
materially incorrect, okay, we'll look into it.
I'll prepare a synopsis for that. Lordship.
Yes, what is the decision Ambale followed? Give us the opportunity to also look into it. Sample were drawn on the spot. Miss Nargis, you look into this then.
Yes, Lordship.
Sample on the spot.
Yes. We have-
Supreme Court is affirming conviction if
Paragraph 10.
paragraph 10.
On the above application of law, it's clear that the innocent burden lies on the accused. It must lay the foundation so that there was no compliance of security fail on the importance of probability, either by reading evidence of its own or by relying upon the evidence of the prosecution. In the present case, no position whatsoever was put to the defense counsel. PW7 is regard section 52A of the NDPS Act. Moreover, apart from here, all the section contravention of Article 6. Like fatigue was has been pointed out. To us, by the evidence that would show that there has been a violation of paragraph of section 52.
No, where is the sample collection?
Lordship, paragraph two, last two lines.
Paragraph two.
Paragraph two, last two lines. The complainant sees others code.
Paragraph two, last two lines. Ah. Paragraph eight.
Paragraph 12 is there. Paragraph 12. See, hearing, so the middle is in there. There is nothing. When you chain of custody. Said central to the exit of the anyway.
There is no application under section 52A also. Admittedly, a seal, but section 52, that this judgment is on paragraph 8 basically. Enter cross-examination PW7, we do not find any question put by the defense counsel as regards 52A. But here is, there is cross-examination.
Oh, that is. Twice.
This has gone some, in a different way. Ambale. Okay. We'll hear Ms. Nargis again. Heard, Ms. S.K. Nargis. For the appellants. As for submission of a land council for the, and Mr. S.C. Kyle, land extending council, NCP, for the respondents. Is present as the submissions of the land council for the appellants have remained inconclusive. List the cases again on next Tuesday for further hearing. We'll look into it here again.
Lordship, further,
Further hearing.
public.
No. What is the case?
So construction is
Sorry.
mostly that Tibu party may come, husband killed by.
Paper was signed.
Occurrence had taken place on 2/3/18 at 10 PM.
Ronji Duran. Nothing there. Other council is present. Open person, passport to adjourn. Go order to the vote. Yes.
Take some time, Lordship.
Will take some time.
Less witnesses are there, only 9
Hmm?
witnesses, only 9 witnesses are there, but here the issue is that whether the 313 statement, that can be treated as confession, Lordship, because apart from
Yeah,
that,
that cannot be treated as
that
confession.
is the issue, so Lordship. may
That
proceed
is
to-
not the, if the prosecution has been able to prove its case
Lordship, that is.
on its own,
on-
that can add to it,
That can,
right? That is settled.
so,
That cannot be taken as confession.
so other circumstance only, other
Whether
circumstance
he
is
had
that,
admitted everything.
he in 313, he said that we were drinking together and he abused my mother and cursed my mother, and out of that anger, I attacked him.
That
That-
can be to admit
that
a case to bring out
Lordship,
the exception,
Lordship,
one of the exception.
Lordship.
It could be a situation. Where is 313?
That your Lordship will find at page 26. And that relevant portion your Lordship will find at page 39.
So any indication about exception 4 somewhere
No, here
during
Lordship,
the
in the
defense cross examination of any witness by defense?
other material Lordship, I have not found subject to correction Lordship.
No, any cross examination?
Cross examination. In the PW7, he stated about some extrajudicial confession, but that thing he did not state in 161.
Hmm.
And that was also denied by defense, that he never admitted about that killing part. First
With
time-
the disease, his friend or what?
His friend.
How many injuries?
In the judgment, it is said 2 injuries, Lordship.
Lacerated
In the
injury of
judgment, in the
size
medical,
10 into 1 centimeter from parietal region. Lesser, okay, left 2 injuries,
twin.
parietal bone. Not a case of single injury.
No.
Your admission at 3:30, it would only wait if it is some kind of confessional in nature. But otherwise, prosecution has to prove its case.
Oh, it's own case. That I will submit tomorrow or something.
Okay. And Farmich will take up tomorrow.
Good.
Yeah, Amicus Curie for the appeal. And Miss, we have an additional, senior counsel, additional senior counsel for the response status. Our present is so, but I need to wait. What it is, just to move on.
Problem.
Rise then. Whatever, like it. It's 4. Yes, 4. Oh,
My senior is on legs.
legs
Yes.
at 4 o'clock, okay. When?
Kindly give us some
Thursday then.
Thursday. Much obliged.
Okay. Your name, please?
Instant color.
The prayer of Swenson. On behalf of Mr. B. Chaudhary, or Miss B. Chaudhary.
Richard.
Kelana, I make a script for that. Please, Thursday. Miss B. Present.